Okay, good evening, everybody. Can we have your attention, and we'll go ahead and get started with our meeting. We'd like to start that with both the invocation and the Pledge of Allegiance. So to lead us in the invocation will be Dr. Jack Sternberg, and then Jock McGregor will lead us in the pledge.
Well, thanks, everybody. Tom gave me 5 minutes to pray, but I think we can communicate with the Almighty in a shorter period of time. Dear Heavenly Father, you know the hearts and minds of everyone in this room. We who are gathered believe that the United States of America, our Constitution and our Bill of Rights were fashioned after Judeo-Christian principles. So it is to you we now turn for advice. Your scriptures teach that the fear of the Lord is the beginning of all wisdom. We know, Lord, that you're always with us. We ask tonight through your Spirit, that we would gain knowledge and understandings of the problems that face our nation. And you would give us the wisdom to know the solutions to our problems. Lord, use our debaters and speak through them. Lord, your words are as sweet as honey, as they are also nourishing. We long to hear from you tonight. So it is in the power of the God of Abraham, Isaac, and Jacob, and in the name of Jesus we pray. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Well, we did pick up time there. That will be helpful. That's right. I want to welcome everybody tonight and thank you for coming out in this weather to be with us for this important debate tonight. My name is Tom Hare, and I am the current chair of the Garland County Tea Party leadership team. And we really are glad that you came here. I'm just kind of curious who might have come the farthest. I know I've seen some names here. How many people came more than 50 miles to be here? Okay, well, maybe I should have started on the other end. How many people came 200 miles or more to be here? And I think we've had 2 or 3 folks there that have. And we appreciate you taking that time to come down here to be with us. I notice we also have some elected officials that have shown up this evening, and we'd like to recognize them. And if you would just stand for a moment so people can see you. We have JP8 Ellen Varhela in the back there. We have State Representative Bob Ballinger. Bob. JP9 Matt McKee. State Representative Randy Alexander. And JP10 Drew Hudgens. And did I see the mayor? Yes. I think we have a few candidates that are running for office, and I don't have your names. Would you stand up and just tell us who you are? Oh.
Mike McCormick running.
Mike McCormick, yes sir, Mike. I didn't recognize you back there. My bifocals was in the way. Yes, Cecilia, thank you. Anyone else? All right, well, we appreciate it. You might be asking yourself, why this meeting? And it's just one of these things that we thought from an educational perspective might be useful for the public at large and our membership to learn a little bit more about our Constitution and what our founders had laid out as far as how the Constitution could be changed, amended, or things repealed. And one of the things that I found personally interesting that affected some of my thoughts about this was this book that Mark Levin put out on the Liberty Amendments. So I bought this book not long ago and started reading it. You know, there's a lot of things in this book that he says I agree with 100%. concerns, though, about how that happens when you actually open up this convention. You know, because I, like many of you, I cherish this Constitution. I do not want to see it destroyed in any way, and that's one of the things I think this debate will begin to help us understand more today. So a lot of it has to do with trust in our elected officials, trust in ourselves about that. You know, I'd like to see nothing more than the 17th Amendment repealed. I think that was one of the major problems that we had in our country when Woodrow Wilson got that passed. I could also get into repealing the 16th Amendment very easily as well. Those are some of the things that Mark Levin, of course, has put in his book. I guess, as I understand it, some of the things that we'll hopefully learn more about today, though, is that Congress creates the rules under the Article 5, as I understand it. We'll see how our speakers speak to that tonight. They determine things like who will be delegates, how will they be paid, a lot of different things as I understand it. And if Congress controls this, and you have the likes of Harry Reid and Barack Obama, I get real nervous thinking about what that might look like, me personally. So I'm anxious to learn more about it as we do this, and I hope that you will be as well. So we're going to kick off tonight some of the pros and cons of a convention. You know, the wheels seem to be in motion about that nationwide right now. There are several states that have already filed application. I think I'm right in saying Arkansas has filed an application. We're not sure. But we have not. We have not? Okay. So to kick off the debate, we found a little short video that's 10 minutes that we want to show that was produced out of Michigan, I believe, to educate legislatures on what their powers, how their powers are limited under a constitutional convention. And it'll also, I think, get you to thinking about some things, not necessarily to state a position, but we thought this was a well-articulated video. And it starts off with a guy named Mark Stubbs, who's a former legislator from Idaho. And he introduces a fellow named Mr. Mark Bork, who's the main speaker on the video. Following the video, I'm going to turn the meeting over to Ms. Susan Clark, one of our leadership folks, who will actually moderate the debate, and she will introduce our debaters at that point. We have another small agenda item after that, but an important item before the meeting is over, and we have Mr. Russ Thompson, who will kind of give us an overview, an overview of our upcoming races in 2014 that we all need to be aware of. So at that point, I'll introduce him, and then we'll close out the session. Okay, and I understand Bruce Westerman just walked in the room. Bruce, we're glad to have you with us. So with that, we'll take a look at this video, and then Sue Clark will come up and introduce our debaters.
Even as a practicing lawyer, I never had the opportunity to take a close look at the process by which we propose and ratify amendments to the United States Constitution. You probably have not had to do so either until now. When I did examine the process, I learned some startling things. America has come dangerously close to requiring Congress to call a convention for proposing amendments to the Constitution. If only a handful of additional state legislatures apply to Congress for a convention, the machinery of a convention will be set in motion. Once this machinery has begun to operate, as former Chief Justice of the United States Supreme Court Warren Burger has written, it will be too late to stop it. There is still time to step back from the brink of a convention, but it will require your attention and your action. To help preserve the system of government and the guarantees of personal liberties which we all enjoy and which we sadly have come to take for granted, please give your closest attention to this message which Mark Bork has presented just for state legislators.
When the founders wrote the Constitution, they devoted all of Article 5 to the process of amendments. two separate and distinct methods of proposing amendments to that Constitution were provided. Those proposed by Congress and those proposed by a special convention called for the purpose. Throughout the history of America, all amendments to the Constitution have been proposed by Congress. The convention method of amendment has never been used. What is an Article 5 convention anyway? Congress must call a constitutional convention, commonly called a con-con, when the legislatures of 2/3 of the states apply for one. Once the critical mass of 34 states has applied, Congress has no choice in the matter. The convention has to be called. The role of state legislatures in amending the United States Constitution is very limited. As a legislator, you have broad powers to deal with matters pertaining to the laws and the governing of your state. But your powers in the process of amending the federal Constitution are of a different kind. The Constitution grants powers to state legislatures to do something which is beyond the usual scope of their authority. The power to set in motion a process which can change the supreme law of the land. This extraordinary power is limited to the precise wording in Article 5. Let's take a close look at Article 5. As a legislator, you are given the powers to apply to Congress to call a convention, if you deem one to be necessary. But you are given no power to decide what topics the convention will consider. No power to write the desired amendment or amendments, and no power to say that the application is ineffective if a convention might violate any restrictions and limitations which you may want to include in your application. Article 5 clearly gives the power to propose amendments exclusively to the convention. This is explicit in the wording of the article, which sets up a 3-step process. Step 1. The legislatures of the states apply to Congress to call a convention. Step 2. Congress calls the convention while deciding other details, such as where the convention may meet, how delegates are to be paid, and how much, how many delegates there will be, and how they are chosen. Note that nothing in the Constitution requires nor guarantees that delegates to a con-con will be elected by the people. Congress is given a free hand to determine the method of selecting these delegates. Congress itself could choose to make the appointment of delegates. Congress could provide that the state legislatures appoint delegates. In short, Congress is given a blank check to determine how convention delegates are to be chosen. It could provide for their election, but it is not required that they do so. Associate Justice of the Supreme Court, Arthur Goldberg, has warned the nation that this absence of any guarantee of electing delegates could put the convention within the control of special interest groups. Writing for the Miami Herald, he stated, quote, "The absence of any mechanism to ensure representative selection of delegates could put a runaway convention in the hands of single-issue groups whose self-interest may be contrary to our national well-being." Ending the quote. Congress also has the power to determine how many delegates each state will have. But note again, the Constitution does not guarantee that every state is entitled to at least one delegate. Step 3. The call is for a convention for proposing amendments to the Constitution. This language clearly states that only the convention is authorized to determine how many amendments will be proposed and what subjects will be addressed in those amendments. During the first 100 years of the Republic, applications for a convention did not try to tell the convention which amendments to propose. That is, they were general calls for a convention. These early applications left the determination of the content of the amendments to the convention which would propose them. In these early years, state legislators knew and respected the fact that only the convention could decide what amendments would say. As time passed, the state legislators of America lost sight of the clear language of the Constitution. Later, they attempted to dictate to a convention what amendments it could propose. They did this by stating in their applications that they sought only a limited convention with authority to propose an amendment on a single subject. By issuing single-issue applications, legislatures sought to turn an Article 5 convention into a rubber-stamped body, a body which could do only what the applications allowed. These unenforceable limitations defied the intended purpose of the convention, which was to deliberate and decide what amendments, if any, it would propose. The wording of Article 5 even authorizes the convention to meet and decide that it will propose no amendments whatever and simply adjourn, if that is what the delegates want. Or if the delegates decide that some changes in the Constitution are in order, they and only they are empowered to determine the number and content of the amendments. This is a far cry from the crippled convention which would be created if state legislatures could dictate to the convention what it must do. What happens if a legislature does include in its application limitations which try to force a convention to consider only one or a few subjects? This has happened routinely in our more recent history. The most recent movement for a con-con has been dressed up as a movement to require Congress to call a convention for the limited purpose of proposing an amendment requiring a balanced federal budget. Other applications have sought a convention only to propose amendments to ban flag burning, to ban abortion, to establish term limits, to let states decide the apportionment of their legislative districts, and many other topics. The topics to which a convention is to be limited are always designed to be appealing. America's leading jurists and legal scholars, however, agree that legislatures have no authority to tell a convention what subjects it will address in a convention. United States Supreme Court justices and the nation's leading legal scholars have written privately that these single subject limitations cannot be enforced. That if a convention is called, it will be free to propose any kind and number of amendments to the same effect as if the limitations in the applications did not exist. In other words, although the applications are effective, all such limitations must be ignored. Chief Justice of the United States Warren Burger wrote, quote, "I have also repeatedly given my opinion that there is no effective way to limit or muzzle the actions of a constitutional convention. The convention could make its own rules and set its own agenda. Congress might try to limit the convention to one amendment or to one issue, but there is no way to assure that the convention would obey. After a convention is convened, it will be too late to stop the convention if we don't like its agenda."
Even as a practicing lawyer, I never had the opportunity to take a close look at the process by which we propose and ratify amendments.
Can we have the lights? Thank you very much. And now what you've all been waiting for, only not that loud. All that loud. I'm very happy to introduce tonight not only the debaters, but also the debate itself. A debate is a formal discussion of a motion before a deliberative body. Tonight, you are that deliberative body. It's also the regulated discussion of a proposition between two sides. This also makes it the best practice for who, when you're litigating, wins or loses, depending on how a case stacks up against their opponent. So please deliberate on the information that you hear from each speaker. After each case is presented and rebuttal, there will be time for questions from the audience. Tonight's proposition is resolved that the state should request a convention for amending the Constitution as they are empowered under Article 5 of the U.S. Constitution. Speaking for the resolution, and therefore first, is Mr. Mark Alspaugh. He is currently the Arkansas Director for the Convention of States Project. Mr. Alspaugh has over 50 years of high technology, engineering, business, marketing, and program management experience. He also has extensive business experience, including formulation of business, strategic, operating, and marketing plans. He is a Navy veteran. Mr. Alspaugh and his wife Betty live in Hot Springs Village, where they have been since 2003. We are very grateful to Mark for being part of our presentation tonight. Speaking second and opposing the resolution is Mr. Antone Blansett. Mr. Blansett is a staff sergeant in Psychological Operations Unit as a reservist and has had multiple deployments in both wartime and peacetime. As a PSYOPs soldier, he has translated foreign language documents in Arabic and Farsi and used this information against enemies of the United States. When his deployment in Iraq ended in 2004, Antone began an intense self-study of the Constitution, the Federalist Papers, and the Anti-Federalist Papers. He has read the minutes from the Constitutional Convention, that would be the original one, and notes from the convention. He is a descendant of a long line of military veterans. We are also very grateful to Tony for being part of our presentation tonight. Each speaker will start with 15 minutes. Mr. Alspaugh.
I want to thank Tom, the leadership of the Garland County Tea Party, for inviting me here this evening for this event. I also want to thank all of you in the audience for attending. You know, this clearly shows that there's interest in this thing that we call a Convention of States. Before I get into the nitty-gritty of it, I'd like to say that, you know, based on the video we've just seen, it's pretty clear that there are some strong feelings about the merits of the Convention of States. I would like to make a contract with those of you who still have an open mind about this issue. I solemnly promise to tell you the truth about the Convention of States and back it up with pointing you to facts that you can verify what I tell you on your own. I promise to do that. The only thing I ask in return is that you keep an open mind, use your God-given common sense, and reach a conclusion based on facts. Now, is that a deal? All right, now they've given me 15 minutes, and so this is going to go pretty fast. Buckle on your seat belts because here we go. This is the cover of the brochure that many of you have, and it in a nutshell tells you what the Convention of States is all about. It's all about the state-led way of reining in the federal government. Now, why is the issue of reining in the federal government even at point? Let's look at what's going on. I'm going to show you a slide. I'm going to buzz through it pretty quick because I'm confident that you will know what the substance is of each of these points that I'm talking about. Washington is broken. Here are the reasons. And it goes on and on and on. We are headed over the cliff as a country unless something can be done to reverse or stop this. Now, we who support the Convention of States proposition believe that Washington will not fix itself. They've shown no inclination to do so, and if there's going to be any solution to this problem, it is going to have to come from a political force outside Washington. There is a way that we the people can fight back, and more than just fighting back, we can win. Article 5 of the Constitution empowers the states working together to bypass the Washington power structure rein in the out-of-control federal government, restrict its power, limit its jurisdiction, restore our liberties, and reestablish the sovereignty of the states. This is not a partisan issue. This is an issue about recovering our God-given constitutional rights. Now let's look at specifically what Article 5 of the Constitution says, and I want to focus on that part of it that deals with the state conventions. On the application of the legislatures of 2/3 of the several states, Congress shall call a convention. Congress makes the call. Amendments that are proposed by a convention, then, when they are ratified, become a part of the Constitution. And we're talking about, you know, this Constitution, not some new and different invented Constitution that comes out of some rogue convention. It's amendments that shall be a part of this Constitution when we meet that criteria. Now, I take issue with many of the statements that are made in the video. They're not factually supportable. The power of Congress, it does say it's limited, but then it tells you it's unlimited. It tells you that they can pick the delegates, they can pick how they're paid, they can pick the number. That is not supportable by law or prevailing precedent. Congress is very limited in what it can do. It can call the convention. At that point in time, it's up to the states to proceed. Let's look at what an application for a convention of states might look like. Now, I want to make clear that we in the project do not write the legislation. This is a straw man that we have put together that suggests the kind of legislation that might be proposed. It is up to your elected legislators to decide what the actual language would ultimately be. But in general, it will be consistent with these kind of principles. Specifically, calling a convention of the states limited to proposing amendments that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials. Now, those are the kinds of things that we're talking about, and it specifically says in the application that it's limited to those things. Contrary to what the video says, it's clear, based upon the precedent, that the purposes of a convention can be limited because Congress has one other important obligation. It's a ministerial obligation. Once a convention meets and puts together whatever amendments they propose, those go back to Congress before they go to the states. The Congress has the right and the obligation to evaluate the proposed amendments to make sure they are consistent with that call. And if they're not consistent with that call, they won't be accepted. It's plain common sense. It's the way things work, not the way that the video misrepresents.
Constitution was written to form a more perfect union that would enable checks and balances to prevent a bloody revolution from being a necessary measure to abolish tyranny. Excellent though it was, Colonel George Mason feared the national government might one day end in a tyrannical aristocracy. The rights of the people needed to be secured against potential corruption at the national level. One of the solutions the framers decided upon can be found in Article 5, which gives state legislators the authority to call a convention that bypasses federal legislators to amend the Constitution. That gives we, the people, the opportunity to make some long overdue structural adjustments. Maybe term limits would be a good place to start. Here's how the process works. Citizens request their state legislators to pass a bill called an application with operative language identical in each state. These legislators of the states then pass the application. Generally, only a simple majority is needed. Congress shall, by law, call a convention of the states as soon as it receives applications from 2/3 of the state legislatures. That's 34 states. Delegates chosen by the state legislatures attend the convention. Each state only gets one vote at the convention, but they can send as many delegates to represent the state as they so choose. Amendments are proposed, debated, and voted upon at the convention. Finally, ratification takes place in the states. Each amendment must be ratified by 3/4 of the states in order to become part of the U.S. Constitution. But what about a runaway convention?
Come.
Let's get a reality check. Like constitutional law scholar Robert G. Nadelson says, there are far more political and legal constraints on a runaway convention than on a runaway Congress. The convention delegates, also called commissioners, are bound to the will of their state legislature.
I want to pause it here and point out that when the delegates from a state go forward, they can be bound by the state law from the state from which they are sent. This is a quote from a current Indiana law, which says that any delegate to such a convention that acts contrary to the charge that he has been given may be charged with a felony. Now, I will tell you that similar language has been drafted in Arkansas that would accomplish the same end. It has not been introduced or yet passed.
If they don't vote as their states demand, they get recalled. They might even get sent to prison. Furthermore, a full 3/4 of the state legislatures, we're talking 38 state legislatures, must ratify each and every amendment in order for it to become part of the U.S. Constitution. Even Alexander Hamilton and Abraham Lincoln, who favored national government, emphasized that Article 5 gives states authority over the national government. Hamilton writes that national rulers have no option upon the subject. The words of Article 5 are peremptory. Congress shall call a convention. And Lincoln says the convention mode seems preferable in that it allows amendments to originate with the people themselves. Article 5 Convention of the States is a safe route to stopping federal overreach. Civilizations rise and fall. Let's be a civilization that saw the cycle of collapse coming and broke it.
What amendments might a convention of states consider? How many of you think that the federal government should live within its means? How many of you think that maybe term limits on federal officials is a good idea? How many of you think there ought to be some limit on the kinds of things that get, in effect, put out as de facto law through such things as regulations, executive orders, and things of that type? You know, and I can go on and on and on about these excesses of the federal government. Now, again, I can't tell you what the convention might end up proposing, but I can tell you that I believe those are the kinds of things that we're focusing on, because we're not talking about fooling with people's individual rights. In the first 10 amendments of the Constitution, the Bill of Rights, we're talking about reining in the federal government to limit the federal government's jurisdiction and their power, rather than doing any tampering with the personal rights of our citizens. So here are some of the kinds of things that might be considered. The founders gave us the Bill of Rights. What we're talking about here is a set of restraints that I will call a Bill of Renewal. That's what it's all about. Now, as distinct from the process, and now talking about the goals of the Convention of States project, we have two major goals: to help bring about a convention call for a particular purpose rather than a particular amendment. We're not going for just some specific amendment. We're going for the purpose that's of limiting the power and jurisdiction of the federal government. Anything proposed must fit within that definition. We also are building a strong grassroots network to develop widespread consensus in the state and set up to help make it happen. Our leadership includes people like Michael Ferris. He's the director of the program. He has over 30 years experience in Washington. He's argued cases before the Supreme Court of the United States and a number of intermediate or appellate courts at the federal level, as well as in the states. He's a prolific author, recognized for his contributions to education. Our deputy director is Mark Meckler, who has a track record with the Tea Party. You know, he was the coordinator for the Tea Party Patriots, and this sort of summarizes his background. The people who are supporting us, here are a few of them. You might recognize Tom Coburn in the upper left. I don't remember who the guy in the middle up top is, but there's Beck, Hannity. Mark Levin is at the center at the bottom. The Grassroots Network will look like this. We have, of course, the national director, and we're establishing state directors in at least 40 states who are building a network underneath them. We hope to have several 100,000 people on board as our Grassroots Network as the project matures. The overarching goal is, you know, we're just the people out trying to make this happen, but the overall goal is to help persuade the Arkansas State Legislature to support a convention of states. The way we do that through our Grassroots Network is we expect our volunteers to urge their legislators to support the project. We want them to attend legislative hearings in support. They will be out campaigning for them as they may, putting their signs in the front yard, putting their bumper stickers on, donating as they're able to the campaigns of these people, and donating as they are able to this project. Now, about the introductory video, you need to check it out yourself to convince yourself whether it's fact-based or not. I believe that if you carefully evaluate it, you will find that it's not fact-based. The Congress of the United States does not pick the delegates, the states do. That's why it's a convention of states. The idea that the Congress will tell it what its rules are is wrong. The states themselves decide how they're going to run their convention. Those are the kinds of misstatement of fact that are in that video that you can check out if you take the time to become fully informed. I reviewed the entire video, which lasts some 30 minutes, and here are my conclusions. My conclusions of the entire video are that it attempts to make the point that convention delegates are bought and paid for and will conspire to replace the Constitution with some brand new Constitution. State legislators are stooges and will enable the conspiracy. Members of Congress and state and federal enforcement officials are also part of the scheme. state legislators will continue their stooge roles and readily ratify the new form of government. I don't believe it. It's what I call Billingsgate. Billingsgate is a word. I'll finish just a couple more minutes.
I already gave you the extra.
Did you? Okay.
I did.
That's what the video is all about. Bottom line, there are two ways to amend the Constitution. Those who oppose the Convention of State basically want to deny people the right to exercise their constitutional rights. Remember the facts. Thank you very much.
It's always difficult when you get on this subject to find out exactly where you want to start, okay? So I'm going to start off with the concept of the U.S. Constitution. The U.S. Constitution does two things only. It controls federal government, it controls state government. There's only like 14 or 15 places where individuals are found inside the Constitution. You'll hear the term resident, citizen, just a very few. And it has to do mainly with the court system and how they get elected to office, who's eligible for elections, etc. That's where you get it. The people are not constricted from changing their government. They do not need permission from the state legislatures. They do not need permission from the federal legislatures in order to change their government. First slide, please. Let's look at this the other way. The Congress shall call a convention for proposing amendments, okay? Whenever two-thirds of both houses shall deem it necessary. The key word here, there's actually two key words. Congress, which is in the absolute middle of it, and the word shall. Shall is often misunderstood. There's three different types of shall, according to, I think it's the Merriman or Mary something Webster dictionary. The second is the one that applies, which means can or may. Because the big issue is two-thirds of the legislatures or two-thirds of the states must call, okay? If Congress can get two-thirds of both houses, then they shall call a convention. But until that point in time, they may not. They have to get two-thirds. That's the fact, okay? They do not have the right to do it at 51%. They do not have the right to do it at 46%. They have to have two-thirds. Because even in Hamilton wrote in 85, two-thirds. He says it's peremptory as long as you have two-thirds. It doesn't matter how you want to look at it, two-thirds must be met. Okay? So in essence, Congress may call. What's going to happen is we're going to go out and do all this work and we're going to submit this application to Congress. And they're going to say, oh, this is a bill of some sorts, this is an application. They're going to go and run it through the committee. They're going to have votes on it. It'll go out to the floor, and somebody's going to say, hey, this is about controlling Congress's power. So guess what we're going to do? Well, all in favor? Aye. Aye. All in favor? Nay. Nay! Everybody who does not like the idea of having their power controlled by the states is going to say nay. And so, guess what? It's not peremptory. They have a moral obligation to do so. I believe that too. But if it's an immoral body in the first place, are we going to go and give them this? Do you honestly believe they're going to do this? So we're going to have a lot of people missing out on a lot of time working on things that we could actually get done, spending millions of dollars in private funds and all that to get something that will not go by. Next, and what I would say is that's probably going to be what happens. They'll just say no, and the talking heads on the radio are going to go, Congress is not obeying their moral obligations. And they're right. Congress is not. They're going to write more books and make millions and millions and millions of more dollars and have speaking tours and all this. But guess what? We're not going to get the convention. And thank goodness for that. Because the overall reality of it is Congress, all they have to do is go to a federal judge and they say, we're going to call this convention. What do we need to do? A federal judge, how many times have you ever found that a federal judge actually stands up for states' rights? Okay? Do we have any lawyers here in Bob? Would you agree with this statement that a federal judge, including Supreme Court justices, often seek to expand the scope, the prestige, and the influence of their courts?
That's like the power.
That's it. So guess what a federal court judge is going to say? Oh yeah, this is a federal matter. This is because it's the federal Constitution and Congress calls it, it belongs to Congress and Congress gets to make all the rules. Congress will make all the rules about who gets to go to the convention, about who gets to do whatever they want to do, because Congress makes the rules. It's a federal convention. That's all there is to understand. It is a federal convention. And then you'll have every single person in Washington that you do not want. You're going to have Bill Ayers, you're going to have Bernadine Dorn, you're going to have Van Jones, you're going to have Barack Obama and all them standing right there at the convention. And then maybe Congress will make some rules about trying to control the convention. But the convention is an independent body. Just like it was in 1787, it went past the scope. A lot of this is based on the concept that the convention did not go past its authorized scope, and that's untrue. Alexander Hamilton in Federalist I, he starts off saying, well, the reason why we went past our scope was one reason or another. When we got into it, it was too big. His two cohorts from New York who left the convention actually stated in anti-federalist objections to the new Constitution, they said, hey, they were going past the scope of what our legislature authorized us to do. So guess what they did? They left. Honorable men left that convention. In fact, so many so, it was a skewed convention. There was 70 that was initially invited, 55 actually made it, but 38 actually voted in that convention. So guess what? If we do get good people in there, which is most unlikely, good people are going to say, hey, I can't stick around and have my name on this. So if they open up the convention, according to this, how many people do not have this piece of paper that was left on your, it's a letter from James Madison to G.L. Turnbull. It's dated November 2nd, out of New York, 1788. If you'll go down to the middle of the page, if a general convention were to take place for the avowed and sole purpose of revising the Constitution, it would naturally consider itself as having a greater latitude than the Congress appointed to administer and support, as well as amend the system. It would consequently give greater agitation to the public mind, and election into it would be courted by the most violent partisans on both sides. It would probably consist of the most heterogeneous characters, would be the very focus of flame that has already too much heated men of all parties. Would no doubt contain individuals of insidious views who, under the mask of seeking alterations popular in some parts but inadmissible in other parts of the Union, might have a dangerous opportunity of sapping the very foundations of the fabric. I have folders filled with all kinds of warnings like this. I also have evidence that all kinds of evidence that these conventions went awry in the first place. Now, they will say, well, you know, even if they do replace the Constitution with another crazy progressive Constitution, we have to have 38 states to vote on it. Let me tell you a little story about the Articles of Confederation. How many people know that you had to have 13 states in order to ratify the Articles of Confederation? How many states do you have to have now? How many states ratified the new Constitution? 9, but 13. But they considered it ratified at 9. In fact, they wrote it in. They get to make the rules. What happens if somebody just just has this crazy idea that, you know, I don't like there being states, you know, these states and their legislatures and all this, it makes it so hard for us to get to the progress where we want to go. So we can wipe out all the state legislatures, and this is the end of the ratification process. It's ratified. Now, most probably they won't do that. It won't be that radical. But they could repeal the 22nd Amendment. So let me think about how this goes about. Let's just say they put it down to 51 states for ratification. And we say, no, it's 3/4. Well, then all of a sudden people start voting on it. State legislatures start ratifying it. That means they accept the 51%. Correct? Does that make sense to y'all? No. It doesn't? We get this, and they say, hey, we're going to go around doing this. Okay? They may not even make this as part of, 51%. Let's just say they stick to the 3/4. Okay? They'll go to conventions. Do we have work that needs to be done at the state legislatures? How many people say we need to really work on our state legislatures? Okay? So we could have the same issue going on. We could have party hacks. We could have all kinds of greenies. We have all that in Little Rock just like we do in Washington. Every state capital has vested interest, corporate interest. They could come in and say, let's do this. Or what if we reject it and send an alternative to it? What if we sat over there and said, we don't really like the way this sounds, so we'll send back a counteroffer. Can we do that? Yeah, we can. Actually, we can. He can make a counteroffer to what was presented to us. So let me ask you, first of all, would this actually work? Would they consider that a ratification if we sent off a counteroffer? Could they? They don't? Okay. So let me ask you, who certifies a ratification of an amendment? Secretary of State, correct. It's through the, what is it called? The National Archivist. Is that not correct? National Archivist has the stamp of the United States. You send it off to him, and guess what he does? He counts it, and he says this is ratified or unratified, and he stamps it. Ratified, or it's rejection. Would John Kerry possibly say, I think this is a ratification if we sent back a counteroffer? Could he actually give one and say, hey, this seems like a ratification? If he has a vested interest in doing something like giving Barack Obama another 2 years or 4 years or 10 terms, could that possibly happen? Yes. Absolutely. Because we already know about Swift vote, do we not? Let's just say they say, well, you're going to do it by conventions. And we say, hey, guess what? It's a state convention, and our legislature makes up the convention and says, this is how it's going to get done. Well, they're going to go back, and the administration and Congress are going to say, I know it's the state's represented, but is this really a state convention since it's about the national legislature? It's about the national, the actual national Constitution. Could you see that there would be something wrong with a judge who would say, hey, I like to expand the scope, the prestige, and the influence of my court. So what would a federal judge say about this? He would say this is actually a federal issue, correct? And guess what would happen? Congress could, huh? Yeah, we could go to the Supreme Court, and that would be a very good idea. But I mean, does the Supreme Court actually have good intentions towards our Constitution? So let me ask you, what's the chain of events here? Congress picks, the National Convention goes down to State Convention, Congress picks that, they ratify. Is that a possibility? I do believe that is. You don't think so, Randy? Well, that's fine. But now, let's just say the conventions that we put up there, they say you can't go past the scope of the conventions because we passed a state law. And we're going to term that as a felony of some sort. We can term it as treason, correct? So let me ask you something. Has anybody ever heard of U.S. Term Limits Incorporated versus Thornton? Does anybody remember the contract with America? What was one of the things that we tried to do? We tried to have term limits, right? We couldn't get it out of the U.S. Congress, so what did we do? We passed term limits in the state of Arkansas on our national delegation. Guess what? It went to the federal court, all the way to the Supreme Court. The Supreme Court struck it down. Said, hey, this is your national delegation. This is not an office that you can control. You cannot stop the term limits of that. It's not up to you. It's a federal issue. So we lost that one again. So you think that law that we have that says that this convention could actually be controlled? Do y'all honestly believe that?
Yes.
You do?
Absolutely.
Okay, well, I'm going to say I completely disagree with you because of past performance. And I also want to bring up McCulloch versus Maryland. What was the overall theme of that?
Basically, it's the Supreme Court has the ability to render decisions on the constitutionality of federal law.
Yeah, but also, did it not set the U.S. government as over the state governments in just about all those decisions?
Actually, the Cooper v. Aaron decision
Mm-hmm.
in the 1950s is the one that, if you're going to point at anything that says that the final arbiter of anything constitutional is the Supreme Court, that would be the case.
Yeah. So in essence, what I'm going to tell you right now is that state law will be overturned by a federal court. It'll go all the way to the Supreme Court, and guess what? It'll be overturned on the basis of Cooper. There's no way that Arkansas law can hold this into check. It does not belong to us. The conventions, even though they're supposed to be state conventions, do not belong to us. Now, I'm not going to even go into the whole process, as I believe that the 17th Amendment should be overturned. I really do. I don't even think it was correctly passed in the first place. As well as the 16th, Jim Bridenstine from Oklahoma actually has an amendment trying to get that passed to repeal the 16th Amendment. So, thank you.
Mr. Alspaugh has 5 minutes to rebuttal.
Okay, thank you. Most of the rhetoric I heard in the rebuttal to my pro-argument reconfirms the cartoon that I showed you. People are no damn good. That's why this is a bad idea. I won't go much further than that. There was a suggestion that the original Constitutional Convention was a runaway convention. Now, that's been an issue that's been debated many, many times. If you check your history, you will find that The Articles of Confederation did not permit the Congress to call a convention. There's nothing in the Articles of Confederation that does that. In fact, the call for the original Constitutional Convention sort of came out of an earlier convention, called the Annapolis Convention, where the states met to try to deal with some commercial rules. They were unsuccessful. They wrote a statement at the end of that convention saying that they wanted to bring together representatives from all the states to begin to develop whatever was necessary to deal with, and here's a word I struggle with, the exigencies, meaning the flaws and problems with the Constitution that was being used for the Confederation of States. Now you have to remember that that particular confederation, there was no judiciary, there was no executive, it was simply a Congress that was generally thought to be sort of one that was formed to serve as a treaty between 13 independent entities. In terms of what Congress must do, most of what you heard is, in my opinion, simply wrong. I promise to point you to the facts. Here is a document that's been prepared by the Congressional Research Service. If you go obtain a copy of this and study it, you will see that the representations that were made here by my opponent are not supported by this. Who is the Congressional Research Service? They are a captive think tank, nonpartisan, of the Congress of the United States, and they study all kinds of issues. And this is what they talk about in terms of the Article 5 Convention to propose constitutional amendments, contemporary issues for Congress. Now, one other thing. We do not call the Convention of States a constitutional convention. You're all familiar with what a constitutional convention is because you grew up with it from the time you were kids. That was an unlimited constitution. An unlimited convention. They could do whatever they chose to, and they did. And they created the Constitution. Of course there was a lot of back and forth. There was a lot of debate and argument and different points of views. But in the final analysis, our sacred document came out of that, which was subsequently modified by the Bill of Rights. I'll stop there.
Thank you. Mr. Blansett will have 5 minutes.
Now, on the concept of whether the convention went past its very authorities, I'll explain a few things. Anti-Federalist paper number 50 by an old Whig. The late convention were chosen by the General Assembly of each state. They had the sanction of Congress for what? To consider what alterations were necessary to be made in the Articles of Confederation. What have they done? They've made a new Constitution for the United States. I will not say that in doing so they have exceeded their authority, but on the other hand, I trust that no man of understanding among them will pretend to say that anything they did or could do was of the least avail to lessen the right of the people to judge for themselves in the last resort. The address of the reasons of descendant minority of the Convention of Pennsylvania to their constituents, December 12, 1787. With this view, a convention was first proposed by Virginia and finally recommended by Congress for the different states to appoint deputies to meet in convention for the purposes of revising and amending the present Articles of Confederation as to make them adequate to the exigencies of the Union. This recommendation of the legislatures of 12 states complied with so hastily as to not consult their constituents on the subject, probably apprehended the necessity to justify the measure. None of them extended their ideas at that time further for revising and amending the present Articles of Confederation. I have several others. They were all out there to say this. In fact, immediately after this convention was ended, they actually had a tussle in order to get the Bill of Rights put in there. In fact, Virginia and several other states demanded that a Bill of Rights be put in. And so in order to avoid the convention, they continued putting these things in. In fact, by the time the end of ratification was over, the Bill of Rights was put in. But immediately after that, they tried to have another convention. Madison had to go run around saying stop for the same reasons that are put in by the letter with G.L. Tuberville. That it doesn't matter what the intent of the convention is. It's what ends up. It's like the intent was to alter the Articles of Confederation. And they came out with a new constitution. I can have an intent and he can have an intent. I can hand him my credit card and say I want a 6-pack of cold Cokes, and he can go out and buy a television set. That's two different intents. Don't get confused with the intent issue. I agree with the original intent why it should be. But the point of Article 5, the reason why it's written, was that states would not go out and usurp the federal government and go back to the same issue that we had in order to have another convention of states or a con-con. The reason why it's called a con-con, especially when it comes to the second part of Article 5, is that there is no insurance that will go against it. No state laws can ever control it. It cannot be controlled because what is in the hearts of men cannot be determined. You cannot give this kind of power away to a group of people that you don't know. I don't even trust myself with it. Thank you.
Ladies and gentlemen, at this point, there is time for some questions from the audience. We think that it might be very limited, so I'm going to ask you this, please. Like the debate itself, this period is going to be regulated in order to have as many questions as possible answered and as much information as possible disseminated. Please be concise in your questions and refrain from making your own comments at this time. We want the speakers to be able to provide answers to those issues which concern you most. I will be selecting questioners, and I will ask you to indicate which speaker you would like to respond. Gentlemen, if you would come over here, you can share, we can sit on the stage or a chair. I'll get you a chair so that you can use the mic to respond. Okay, go. Now.
I'd like to address the against the I can hold it?
Yeah.
I have it? Thanks.
Okay.
It seems that there is contempt in your argument for the original drafting of the Constitution of the United States and the gentleman that did it, even though it wasn't called for by the Constitution we currently live under. It was called for under the Articles of Confederation. If you don't believe that individuals are capable of electing just representation, and you don't believe that they are capable of making the decisions that to send responsible people to Little Rock, to Washington, to do those things, even though we've had problems, if we're not capable of that, how can this experiment in self-government succeed at all?
Well, that's always a good one. It's one thing to elect somebody to a government so narrowly defined. If Congress was obeying the law in the first place, we have this Constitution, it's been there for all this time, and not until recently have people sat over there and said, we got to change it. Now, we've had people want to change it for all kinds of different reasons all through the ages. But they didn't try to do it this way for a reason. It can't be done safely. Now, do I trust that that people can do it? Yeah, that's the reason why the Tea Parties exist. That's one of the reasons why I went out and I ran for office. And I won. But the important part of it wasn't because of any other reason that, a lot of people don't think a constable is that very important. But more importantly, when it comes down to the whole concept of, do you trust the people in Washington? I'm going to say I don't. And when I look at the money that flows around Little Rock, I'm going to say I don't. Not all of them. We have two reps right here who took the time to come in because they want to know the truth. But the whole point of it is how many reps are not here?
Okay, Mr. Blansett, I'm going to keep answers short as well if you feel like you got your question answered. Matt, sir, you were next.
Are you aware that Hamilton and James Madison were a very small minority that wanted concentration of power at the federal level, and they were sour grapes at the convention, but the vast majority of the people at the convention, what the framers' intent was to give the states power and have very limited power at the federal level. Were you aware of that? Because this, I don't believe, is a valid thing to hand out.
Well, yes, I am actually aware of that, but except for actually Madison was much more of a small government person. He ran as an anti-federalist in the later, right after this, he ran as an anti-federalist. Hamilton was actually a monarchist, and he'd like to have a large, would like to have had a large national government. I actually have the very first one that they drafted where he demanded that the president be called His Majesty.
Okay, well my question, let me get to my question. My question is, you state in the Tea Party platform, which by the way, I'm a combat vet. And most of the combat vets that I associate with are very conservative people, okay? As part of the Tea Party, you're saying that government is best handled the closest to the people. I couldn't agree more. How do you plan to achieve that when you get to the federal level and those people are controlled by multi-billion-dollar campaign funds that are, when those dollars go into those campaigns, they want payback, okay? I trust the state legislator 1,000% more than I trust anybody in.
Would you state your question? We're going to keep the
That's my
question.
question. That's my question. I said, you say that it's going to be runaway. I say that they have a states convention, they come up with logical amendments which the American people support, and they try to pull this business you're talking about. I think they're going to have their hands full, big time.
Well, I would love to be able to say that. If you'll go back to it, you'll only see that the convention proposes the amendments, not the state legislatures, not Congress. They have nothing to do with it. The conventions make they're the ones who make the amendments to be thought up of. They may accept the whatever Congress hands to them, but what Congress gets from the state legislatures are an application only, and that's all it is. The reason is irrelevant to Congress. It's an application.
Okay, Ms. Cowan.
Mr. Alspaugh, you said that you put up a thing on the screen that said this is a list of what might be considered.
Yes, ma'am, I did.
What's the guarantee
There is no
that's
guarantee.
what would be considered?
There's no guarantee, with this exception. Excuse me. There's no guarantee of the specific amendment that might be proposed, but the call for the convention establishes the basic rule. It is bounded by the specific call that says they want a convention limited to amendments that would be proposed that would reduce the power and jurisdiction of the federal government and impose certain fiscal constraints. Now that is, if it fits within that reservation, then anything could be proposed. And it includes the kinds of things that I showed. Anything outside that would be inconsistent with the call and would not be proper.
Thank you. Okay, Mr. Lewin, I had you next.
You said we need this convention to set up these rules. We seem to have enough rules now as it is. We can't get the government to stick by the ones we have. Why don't we just try to enforce our legislatures and our senators and everything to stick to the rules that we have? Because I think the Constitution that we have is more than adequate, and we don't have to add to it.
Well, that does not have an easy answer. The onslaught against the Constitution has been underway for 100 years or so, going back to when the 17th Amendment was put in. It's been a gradual erosion. Now, when you say something that there's a whole bunch of unconstitutional things out there, the fact is that what's going on has largely been held to be constitutional. Well, we don't agree with that. You and I probably don't agree with that, but we don't represent the law of the land. So the only way that we have to recover from the situation we're in is to amend the Constitution to more carefully define the limitations of our federal government and to restore what is the rightful sovereignty of the states.
Okay. Ms. Sanders is next.
I don't need a microphone. I'm pretty loud.
She's got it.
I have a question for Mr. Alspaugh.
Yes, ma'am.
Which is in kind of in line with the gentleman that was before me. No. Are you familiar with the credit bureau system, the credit rating system and the credit bureau system that we have? You're familiar with how they work?
No, ma'am. I am not familiar with it.
Okay. If a person applies for credit, your credit history is examined, and then based on your credit history, you are either granted or not granted credit, right? With the track history that we have of our runaway government, our rogue Supreme Court system, our rogue president who seems to be able to do anything he wants to do and get by with it, what makes us think that if we change the Constitution, they will hold to that Constitution when they're not abiding by it right now?
Well, let me answer that in this way. If we have such a convention and they're setting about to rein in the federal government, let's do things like repeal the 17th Amendment for starters. If our senators in Washington know that they're going to be held accountable by our state legislatures rather than the political power structure in Washington, who do you think they're going to respond to? Today they respond to the power structure in Washington. You do that with the 17th Amendment, and you bring the accountability for senators' actions much more effectively right back to the state. How many think Obamacare would have been passed if the senators had been persuaded to vote the way the populations in their states viewed that? You know, it would never have passed. Now, secondly, let's limit the terms. You know, we have people sitting in Washington becoming millionaires, and they're there for 40 years. Let's have reasonable term limits for federally elected officials, including the Supreme Court. Let's have an amendment that establishes a Supreme Court of states over the Supreme Court of the United States, so that if there is consensus in a Supreme Court of the states that the Supreme Court has overstepped its bounds, the states have the tools to deal with that. So those are some of the kinds of things that one could suggest or think about as ways to correct the kind of misuse of power that takes place in Washington.
One little follow-up question. If what happens, you propose, what happens about the Supreme Court of States, is that what you called it? A Court of States?
Say again, ma'am.
What did you say you proposed over the Supreme Court? What was that?
A Supreme Court of the state, a Superior Court of States.
Superior Court to the Supreme Court. Isn't that like adding a layer of bureaucracy to an already overburdened government?
If you want the states to have some say, look at it this way. We have Obamacare because of one man. Who's that man? John Roberts. If John Roberts were true to his original principles, at least I believe this, we would not have Obamacare. You know, one vote changes the entire state of things in this country from one end to the other. If we have a Superior Court of States that could look at that and by some appropriate way of voting on such things, reverse the Supreme Court, then we're going to have a lot more control over some of the stuff that's going on in Washington.
Thank you very much. Mr. McGregor, you were next.
It's all well and good that there's lots of great ideas about what we could do and what we could not do. I think some of these amendments would be great ideas. The problem that I have is that you have said several times that the states can do this, can do that, can do all these various wonderful things. Where in the Constitution does it say they can do that? What are the precedents that are going to allow them to do that?
I'm not sure I understand the question. Let me try to answer it in this way. In terms of the way a convention of states would operate, the internal procedures for it, those kinds of things, that is up for the convention of states, the delegates to the convention of states to decide. Now,
where's their authority come from?
Well, what authority beyond calling the convention of the states is necessary?
In other words, you're going to just throw out Article 5.
No, didn't say that.
Well, then how are they going to get their authority to do this?
Article 5, well, let me try to describe a situation that might be undertaken. A sufficient number of states call for a convention of states. Congress decides that it has met the obligation of Article 5. It then calls a convention of states. It sends the appropriate communication to the legislatures of all 50 states, and Congress's obligation at that time is to essentially convene the convention. You know, someone like Joe Biden would walk into the room and hit the gavel and say, this convention is now convened. What happens next?
That's my question.
That's a good question.
Where does it go beyond Congress? How does it get back to the states? The only thing it says in the Fifth Amendment is that Congress shall do whatever.
It says they will call the convention.
That's right. And what are the rules for the convention? Who makes
them? What are the rules? Well, let's talk about something that makes common sense. Everyday common sense that everyone
There's no common sense in Washington.
Okay. but there's common sense in this room.
Yes, there is.
There's a lot of it. Now let me answer your question. There was a meeting called the Mount Vernon meeting that happened a little over a month ago, the first week in December, and some 97 representatives from state legislatures around the country met because they said, what's coming down the pike is a convention of states. We better figure out how we want to run a convention. So they met to begin to talk about how to do that. They're going to meet again to talk about how they're going to do that. We have people involved here who are not stupid. They're not out to grind their own axe. They're out to take on a chore, a task that is important to this country as the original founding fathers.
I accept all of that.
Okay, that's how it happens. They will develop the rules.
When Congress says we're going to run the show, what do they do? What's their authority to say no, you won't?
Well,
and how will they do that?
I would suggest to you, I gave you a reference earlier. Look, it takes a lot of work to dig it out, but if you look at what the Congressional Research Service has said about what the duties and obligations of Congress are, it does not include getting into the substance and innards of the convention. That is strictly left up to the states through their delegates. And again, I'll cite that reference and look it up and study it.
Given the propensity for the president to do whatever the hell he feels like doing, what makes you think that that the federal government would honor anything that was done by the states?
I guess if you are asking for absolute certainty that there is zero risk in anything that you do, then I don't have an answer that will give you that. But let me ask you this question. What is the risk if things continue like they are in Washington?
Well, I think that we have some opportunities to try and turn things around. One is by election, and the other is by asserting states' rights or state sovereignty and using those methods to force the federal government to do it. They cannot come into, for instance, Garland County without the permission of the Garland County Sheriff.
Article 6 of the Constitution clearly.
Well, I'm not saying they don't do it, I'm saying they're not supposed to do it.
Federal law has supremacy over state law. Now, you can go poke a finger in their eye and say you can't do that, but if they decide they want to do it, they will do it. You know that, and I know that.
We're going to go to the last two questions. Mr. Godwin? I bet you, oh, look, you've got a mic.
Yes, my question's for the other speaker, and perhaps I missed it, but what is your alternative to reining in federal spending jurisdiction, if not a constitutional convention?
I'm glad you asked. We actually have something called nullification and interposition. The main people, Mr. Ferris, Mr. Levin, many other people say that this is an impossibility. It's a pipe dream, that it cannot be done. In fact, Mr. Levin actually claimed that James Madison spoke against it in the 1830s, and that's not true. We have a right to an opinion on our Constitution, especially if it's so blatant. Okay, if we say that I don't know, we don't believe in health care can be mandated to us, we can actually do things like have our legislature interpose or nullify that by saying that's not written into the Constitution, it's not part of your enumerated powers, and because so you're treading on our jurisdiction, you're treading on us as a state. So we will use the 10th Amendment, we will invoke the 10th Amendment and say, no, you will not do this. In fact, over 30 states are now nullifying Obamacare. And nullification happens all the time. People will say, oh, you can't nullify, you can't nullify. The liberals do it all the time. The state of Illinois, quote, nullifies the Second Amendment. They say you can't have a gun. That's a nullification. It's wrong. It's called breaking the Constitution. But when it's not, when there is something that the federal government is specifically saying, hey, we're going to do, and it's against their enumerated powers, we have the right to do that. And interposition, the sheriffs, one sheriff kicked out all the federal agents in his county in California, all the forestry people and all that. Kick them out. So we got to get our legislatures and our county judges and quorum courts and all that to get over there and say we're going to use our constitutional positions to nullify a federal overreach. That's the best way of doing it, and it's not a whole ton of work that you can spend doing other things like educating people on the Constitution, how to vote in the next election in order to capture Congress, so we can actually have amendments to the Constitution to repeal the 17th Amendment. Because what you're going to have to do is capture Congress. That's what has to happen. We're up against a huge machine, though.
I need to comment about that answer.
Okay.
Nullification sounds good on the surface. You know, it's kind of fun to go poke your finger in the eye of the federal government. Colorado has done that recently by making marijuana available as a recreational drug, while the federal law says that possession of marijuana is a federal offense, it's a controlled substance. So we now have a federal law and a state law that are in conflict, and that's a form of nullification. Now, eventually, as long as the federal government doesn't do anything, it stands. But you'll have one state that doesn't like Obamacare, another state that doesn't like the way marijuana is controlled, another state wants to let cocaine become a recreational drug, and somebody else wants to have something else. And all of a sudden, you've got people trying to nullify various kinds of things, and eventually, that big giant in Washington is going to get fed up and take action. It just leads to disrespect for the rule of law, and it leads to anarchy. And in the long run, nullification, while it's real excited in the short term, in the long run, nullification creates a whole bunch of problems that could lead to essentially the disintegration of our society. So.
Sir.
I'm Levi Davis. I think
think we're about to anarchy at this point.
Thank you, sir.
I'm going to agree with this gentleman over here. I think we've got a constitution, and that constitution has been working pretty well. I think the problem is that the people we elect and send to Congress are not doing their jobs. When you start talking about balancing the budget, why do we have to force them to balance a budget? I mean, that bothers me. The other thing I wanted to ask was that, when you're going through the steps that we take, Congress picks the delegates, state picks the delegates. Well, I've got to go back, and Nancy and Linda, I've got to go back and tell our people what we gained up here. And Reggie told me their food would be clear when I left.
I think it was a mistake.
No, the last step that Congress and the delegates will go through to pass any constitutional amendment. What are those steps? The delegates go in and they vote on the recommended amendments. They come out. They go back to the states, or they go to the Congress.
Well, let me describe it this way. When the convention concludes, they will have put together essentially a statement, a bill that says, here are the amendments that we propose. And the specific language of those proposed amendments will be in that piece of paper. That piece of paper goes to Congress. Now, Congress, to the United States Congress, the obligation of Congress at that time is to make sure that what they have proposed is consistent with the call for the convention, that it fits within the framework that I described dealing with the limitations of the call for convention. Once they determine that, then that paper or those proposed amendments goes to every state in the Union, and those states then undertake a ratification process in their state. They do whatever, they will go in. Well, eventually, yeah, the ratification requires that 3/4 of the states, 38 states, have to agree on it. For example, suppose there were an amendment in there to balance the budget, and 35 agree, and that's all you get. That amendment falls. If there's an agreement in there that's term limits, and if it gets 38 or more votes, it goes. It's only those amendments that would be proposed that reach that threshold of 38 affirmative votes in the states that become a part of the Constitution.
Okay, then we get 38. Does it go back to Congress, or where does it go?
Well, yeah, it goes back to Congress, and it becomes enacted then as amendments to the Constitution in the same way that all the other amendments have been enacted. There's nothing new about the enactment process. Those particular steps are identical for both amendments that originate in the Congress and amendments that would originate.
Okay, does it go from the House to the Senate, or where does it stop? Where does it go into the Constitution?
You know, I don't understand the question, because it doesn't go in for debate in the House or the Senate. You know, I should know that, but I honestly don't. Do you have something to add, sir?
When the states ratify those amendments that require member states, they become part of the Constitution.
Yeah, they're part of upon ratification.
One at a time, and then they go into the Constitution. They don't go back to Congress.
As soon as they're ratified, they become part of the Constitution.
But then each individual state's going to ratify it, right?
Yeah, right, 38.
38 states.
38 close.
The states then, goes back to the states.
Okay.
They have to vote for those amendments.
And then it's
And
2 or
like
3.
Mark said, if you get 38 states that say yea to Amendment 1, yea to Amendment 2, or whatever, if there's 38 states that agree with it, it becomes law, it becomes part of the
But
Constitution.
it has to agree with each of the amendments.
Okay, gentlemen, we're going on now.
Okay.
We're starting to ramble here. I would like to give 3 very short minutes, your closing comments. You're at the mic, go.
Okay, I think I've pretty well said everything I need to say. I believe that the option of a convention of states is a gift that the founding fathers gave us. I think if you check the historical record, you'll find that if it had not been in the Constitution, because that Constitution had to be ratified by the states, there are people who say that it is unlikely that our Constitution would have been accepted by the states. The rules of the convention are set by the delegates to the convention. The role of the U.S. Congress is very limited to calling for the convention, for assessing the responses to make sure that they fit with the convention. Might mention that this idea that anything that goes into an application would permit people to go anywhere. You know, we've had over 400 applications for states. If it was just a matter of numbers, then the threshold for 2/3 of the states had been reached over and over and over. And the reason there's never been a convention of states is that there's never been 2/3 that were focused on the purpose, a common purpose and a common objective. And that's the distinction that we're making now. Still takes 38 states to ratify. The convention cannot change one word of the Constitution. It takes 38 states to ratify any proposed convention or proposed amendment. Thank you.
Thank you very much. Closing comments, Mr. Blansett.
The issue is, do we have an honest Congress at this time or don't we? Okay. I believe, just like he believes, that under normal, I believe that the intent was there for us to have good, honest, godly men running this country that we could elect. But more importantly, I believe that that is not the condition that we have now, and to give them that much power and influence with a Supreme Court and other lower courts being so far down the road away from our Constitution, that it is just way too damaging. And I could say this, if you want to know just how corrupt a government has gotten, go look at their capital and then go to the furthest extents of the capital. You will see stark contrasts. You'll see how big the capital city is with all the nice streets and beautiful buildings, and then you will go to the furthest extent and you will see the poverty. That's where the corruption is. If you think about it, that's what you see here in the United States. That's where I've seen in all the countries I've ever been to. We do not have a Congress that is to be trusted, nor a court system to be trusted. And I will also say this, when you start thinking about it, we have all kinds of special interests that are out there, and they just cannot wait to get into this so they can do whatever they want to do. And until we solve the issue of the Federal Reserve, the balanced budget amendment is dead. Absolutely without any merit. Until we get rid of the Federal Reserve. Thank you.
Thank you very much. One of our goals, of course, was to give you as much information as possible. And Mr. Alexander is not going to make a speech, although we'd love to do that another time. But he is going to give you access to a resource that he's going to give us, and we'll get one as well that might be for the other side. There you go.
Bob Ballinger and I, along with 2 other state representatives, were at the Mount Vernon Assembly. We participated in the event. And I would be happy to share information as we get it, and also try to answer any questions that you may have. I want to give you my email address, and you can send me questions, and you can ask to be put on a mailing list or whatever, and we'll take care of that. My address, this is my personal address, is alexander@reagan.com, R-E-A-G-A-N, just like the president, alexander@reagan.com. I used to be opposed to this. I'm not anymore. To me, it comes down to one simple question. We all know we're going in the wrong direction, been picking up speed. Do you believe the solution's going to come from Washington? I don't believe that.
Thank you very much.
Thank you.
At this time, I'd like to introduce our own Diane Silverman. And Diane is going to do summary remarks, but more importantly, she is going to transition us into the next part of our agenda tonight.
Very good. Well, we have heard a lot of words tonight, and I imagine some people like me are somewhat confused as to exactly what was said and what was meant by what was said. I think I'm going to start at the end of what I wanted to say rather than at the beginning, because the controversy just in this case here tonight is a group who thinks that they can control a con and a group who says we can't. And I mean, that's the difference. So that's where it stands. And there are other people that have other points of views somewhere in between. Whether you read the Constitution, Article 5, and you want to read it in its pure form and take it like that, there is nothing in Article 5 that calls for a convention of the states. You will not find that phrase in there. So somebody in their own way have decided that the Article 5 calls for a constitution of the convention of the states. It doesn't. It calls for Congress to call a constitutional convention for proposing amendments when 2/3 of the states petition Congress to do that. It says it shall, and shall has always been defined as must. If it didn't mean must, it would say they can if they want to. The Constitution isn't, I mean, Article 5 is small enough that it's very clear to understand, and anybody who wants to look at it and not insert their own subjective thinking and just read what it says will get the impression that I have. But somebody else who wants to do it their own way, they're going to get what they have. And that's the crux of the issue. And from that point all the way as far as it goes, you will have arguments, you will have chaos, you will have contention, you will have the Supreme Court. There's nothing for sure. Nowhere in Article 5 does it say that the states control the convention. It says Congress will call the convention and Congress will control the convention. And it also says when it comes to the ratification that Congress will decide the mode of the ratification process. Now just read it and you'll know that. You'll for yourself, you don't need anybody to explain it. Basically, there's an organization called ALEC, the American Legislative Exchange Council. It is a very powerful organization, and it creates model legislation for legislators in a lot of states. And people are used to following ALEC, and they sort of think if ALEC says it, ALEC's researched it, and they know what they're talking about. But ALEC or anybody else, as powerful as they may be, and as much money as they throw around, and as much influence as they think they have, cannot prove to you that a constitutional convention will not run away, open it up, and let the special interests that control Congress have their way with it. So it's Congress that we're afraid of, not the people. I agree with that. But there is no proof that the VIPs proposing an Article 5 convention have any first-hand knowledge or proof that they can control Congress or that they can prevent a runaway convention. All the examples we have seen in recent years of Congress being controlled by special interests for favors received or to ensure their re-election, that's what we believe because that's what we've seen it, right? We see that happening every day. So to ignore the enormous pressure that organizations like RAZA, the Hispanic power group, and the Muslim power group, and the Black power group, and the this power group, and I mean, that's what's running our Congress. And if their needs or their ideas are not met, they're liable to riot. That's what they do. Remember Governor Walker in Wisconsin when he tried to do something with the education law? My God, it turned the whole state upside down. Everything went wrong. Well, imagine that happening all over the place. People just don't disagree. I mean, they just don't agree. So if they're going to riot at the drop of a hat, you know, what could happen? Well, we could have martial law. We could have the election stopped. You don't know what's going to happen. I don't know what's going to happen. But the risk isn't worth it because when you boil it all down, there's only one job we have that can make a difference. And that is to kick out the slime and vet and elect constitutional, conservatively constitutional candidates. And if we're not willing to do that, If we're not willing to put ourselves in the trenches to do that, then we ought to just go home and forget it and let them just wash over us and knock us off the playing field. Because that is the only thing for sure that we can do. In 2010, we did it. We wiped the county clean. It is no longer corrupt. It listens. It's got good people. They're good people that are there, not going to allow bad people to come in. It's just, and it just doesn't make any sense to be trying to control the United States Congress if we're not willing to control our city, our state legislatures. And so far, we've been really lazy about doing it. And if we're going to be lazy about doing it, 2014 is going to come and go, 2016 is going to come and go, and we're going to be in deep doo-doo. So the choice we have, to me, isn't between a con-con or no con-con. Forget the con-con. I think it's just going to be a waste of time and probably go nowhere. But it'll create a lot of confusion. It'll take people's focus off of what needs to be done. So the point of view of the Garland County Tea Party is that the reality is that Congress is not composed of a conservative majority. The reality is that the liberals would love nothing better than to put the United States Constitution on a chopping block and replace it with a new progressive one. Anybody who knows Agenda 21, anybody who knows the New World Order, anybody who knows the One World Governance has got to know that we have no choice of what is going on unless we elect enough people who are willing to stand with us and defend us all the way. And that's what we have to do. If you can't get out there and vet enough people, not by what they say, but by their actions, by their history, that they will stand with us, then you're not doing your job. Don't go out there and elect people you don't know for sure. Don't go by their hairdo. Don't go by the clothes they wear, the car they drive. We need constitutionally conservative candidates. And in Garland County, we're working on that. We're going to have a constitutional sheriff in Garland County. We're going to have a great Division II Circuit Court judge who deserves to be in that position. The Tea Party's job is to find these people, vet these people, and elect these people. And that's our job number one, job number two, and job number three. And get rid of this constitutional convention idea. The Tea Party does not want Arkansas to sign on to that. Thank you.
Well, this has been a very stimulating debate and gives us all a lot to think about. We have one more speaker, and Russ Thomas. He's going to kind of outline a few key things about some of the races, because I do think that at least that's one first step that we can begin to take this next election season to see if we can get some more constitutional conservative people in office. So Russ, if you'll come up and take us through that.
Thank you. I think one thing we've figured out here is that Washington can't fix itself easily. But as I look around the room, I see a lot of people here who actually have done a lot of fixing in Hot Springs. There's Diane, here's Bob. I saw the mayor sitting next door, sitting back there next to the fellow who tried to change the form of government in the town. We've got a lot of movers and shakers in this room. And though you can't easily fix Washington, you sit there and watch Fox News or CNN, you just get frustrated. It feels like there's nothing you can do. But on the local level, you absolutely can do it. If we can strengthen our local governments, if we can get good candidates for school board, for example, then you start there, you get the leadership skills, and you move your way up to where you finally can take over Washington, or at a minimum, if things do go bad, at least your local governments are strong enough to take over for what the needs are and such. So with that in mind, I'd like to start with the, this is going to be JP. Okay, can we get to the city districts? No, still JP. Anyway, starting at the top, and I think they're passing out a sheet of what the different races are this year and who the candidates in some of these races are. The first one was school board, and so few people even know when the election is, where the election is, how you run, that this year Hot Springs School District had 0 candidates for school board. It's just an amazing situation that they control more money. The school districts control far more money than the city and county put together. And when it comes to local taxes, they have like a dozen times or so tax collection of what the city and county combined have. Bruce Westerman, who just left here, credits his start to being on the school board and learning how to deal with people who had a different opinion than you did, and how to make it work and get together. And he rose to be the first Republican House Majority Leader in like 128, 138 years, something like that, since Reconstruction. So, you know, school board is where it starts at. It doesn't take a lot of money. The number of votes cast in the school board election goes anywhere from 2 or 3 at the Lakeside School election about 5 or 6 years ago, up to about 1,000 or so if you have a candidate that's kind of ruffling the local school district's feathers, and they get all their employees and such out to vote. But anyway, school board is where it starts. If you know anybody that's conservative that you would like to see help determine how your tax money is spent on a local basis, the school board is the first, easiest place to start. So I would encourage everybody to look at their local school board race. Candidates go ahead and get about 50 signatures, I believe it is, in the summer in June. And then they have an election in September, which is generally at the school, not the general election that we have for the community. The exception to that is that the college has candidates, and those that go on in the general election. Okay, moving on from the school to the city. These races have a filing period that starts in August, and you go around and collect some signatures, about 50 again, I think it is, and you file by an August deadline, and then you're on the general election. These are not Democrat and Republican partisan races. These are just nonpartisan races. There is no runoff. Whoever gets the highest number of votes wins. So if you have 5 people in the race, there won't be a runoff regardless of if anybody gets 50% or not. Anyway, citywide we have the mayor, and Mayor Ruth Carney is here. She will have a progressive candidate to face her this year. We may even annex one in for her. I think that's kind of been floating in the newspapers lately. But anyway, Ruth has done a great job as a conservative mayor, the first one we've had in this town in a long time. She's going to need folks to get out there and fight for her again like we did 4 years ago, and I hope everybody in this crowd will walk over to her and ask her how they can help tonight. But anyway, beyond that race, there are no announced candidates that generally won't come up until sometime in the summer. We have District 2, Elaine Jones, who is up for re-election this year. And we have District 4, which is Pat McCabe. Now, District 2 is considered the minority district for Hot Springs. When they designed the districts, we have to have a majority-minority district. So they designed the whole city around District 2, which is why you see that strange structure for District 6. Green, the darker green in the middle is District 2. So if you know anyone in that area that would like to run this year, we do need a good conservative candidate in that position. Districts 1 and 6 and 5, I believe it is, were in the election 2 years ago, so they have a 4-year term that won't be in this election. District 4, which basically goes out the Albert Pike area, it's the district in blue. Pat McCabe is up for re-election in that district this year. And then District 5, the large green area down at the bottom of the city, Karen Garcia is the representative in that district. Karen is a Democrat, but I think she's an example of where Democrat and Republican don't matter in the city position. She's a very conservative, very good director, and proud to have her there. But she will be up for re-election this year. Moving on to the county, and we have the city side of it, or the JP districts that are within the city. Oops. I think I may have been looking at the JP district. This is the county JP districts that are outlying away from the city, the gray area. There's so many JP districts in there, the map doesn't show it. But in this, we've got District 12 and 13 are the ones to be watching. The reason for this is Bruce Westerman, who just left the room, is going to be running for Congress. Currently represents a House district that covers a good area of that 12 and 13. So as he tries to run for Congress, it leaves that state district open. There's 100 representatives in our state house. And so vaguely in that, the two purple areas, we'll be looking for a candidate, and it appears, and right now no one has filed for office except for a couple of judgeships that are available to be filed for yet. Most people are filing in March. So most anything I'm going to tell you today about who the candidates are is pretty much rumor, because there has been little or no filing at this point. Most of that will happen by March 3rd. But anyway, you've got the JP Donald Lehman from District 12, who will most likely be running against the JP for District 13, Mickey Gates, for that House seat. That will leave these two JP districts open, and the JPs basically run the quorum court or run the county. It's a body of 13 people that do the voting for how the county spends their money and sets regulations and such for the county. So JP District 12 there, the light pink, we don't have any candidates rumored or anything at this point in that area. That's a real focus area then in the county. If you know anyone who lives in that area that you know like to step forward and run as a conservative, we'd love to see them. JP District 13 over here, where Mickey Gates is vacating office, there currently are about 3 fairly conservative candidates that have been rumored to be running in that district. So I think we're probably going to have some good choices in that district. If we have a slide that shows the JP districts in the city, Mary Bourneville currently is a JP for District 4, and she will not be running for re-election this time. And there is no one rumored, no one talking about running for that district. So if anybody knows anybody off of that Albert Pike area that would like to run, we're actively seeking a candidate in that area. The only other city JP district that the Garland County Tea Party has indicated that they're looking at as a focus area is JP1, which is up in the northern part of Hot Springs. It stretches out towards Magic Springs. And we have a fairly liberal JP in that district that doesn't really meet the Garland County Tea Party's desires. So anyway, that's the JP races. Moving on to the county-wide races. These are in no particular order, but the first one, we have a juvenile judge position, which is actually just a circuit judge, but right now that has served as a juvenile judge position and probably will after this election. We've got Vicki Cook, who's retiring from that position, Wade Nairmore, Mike Crawford, Cecilia Dyer, and John Howard are running for that position. It's a good slate of candidates. We will end up with a good juvenile judge out of this slate, I believe. I think one thing you can read from it is that if I held out 3 blue marbles, 1 pink marble, and went around the room and asked everybody to grab a marble, it would be pretty obvious, I think, that the 1 pink marble would probably get more takes than the others, because the other 3 are going to kind of split the vote on that one. Now, these candidates are good, qualified people. There's other reasons people vote for, but there is a randomness about all these elections where people don't know what they're voting on. So I think with that in mind, you're going to see that Cecilia, who's back in the back of the room, is very likely to be in a runoff after this May primary. There'll be a runoff probably in November and I suspect it'll be Cecile and one of the other candidates. Okay, going on, we've got sheriff. This is going to be the most contested race in the county at this point, I believe. On the Republican side, you got Fred Hawthorne, Ronnie Dunn, and Scotty Dodd running. Fred Hawthorne and Scotty Dodd are assumed at this point to be the 2 strong candidates who probably end up winning a runoff. I suspect that Fred Hawthorne would probably come out on top of that, face off Rodney Neighbors, the Democrat, and Mike McCormick in the fall. That runoff will be a real interesting thing. There's only been 2 similar runoffs in recent history in Arkansas. And Mike McCormick, who's in the back of the room, is likely to end up in that runoff, and independents have a really good chance in these type of runoffs because 37% of the people identify themselves as independents in the state of Arkansas right now. In the county judge race, we've got Rick Davis running, and Clay Herman is running as an independent in that race. In the assessor's race, we've got 3 good candidates, Shannon Sharp, Gary West, and Steve Thacker. And the state representative, District 22, I think we got a map of that up here. I've already mentioned that that Mickey Gates and Donald Lehman will be running for that race, in that race. Moving forward down to District 14, State Senate. And by the way, I don't anticipate any Democrats, independents, or anything in that District 22 race. District 14, Bill Sample is currently the representative in that district. He is a Republican, and the Garland County Tea Party is actively seeking another person to run in that race because of some disappointments with his representation. If you want more information on that, if you go to Arkansas Watch and look at some of the information they have about the University of Arkansas financial situation that's been in the news lately, and Bill's involvement in that, as well as private option and some other issues, tax issues. They have kind of an analysis of his performance there. If you know anyone who lives in that District 14, we really would like to know a good, strong leader to step forward and run for that. Okay, moving on to the state offices. The 2 most important there are the governor and the attorney general. The attorney general can sue the federal government, just like Arizona has done on a real frequent basis. The governor doesn't really have a veto power in Arkansas. His veto is overridden by 50%, or 51%, so it's very limited there. But they set the agenda, and that's very important. In that race, we got Mike Ross and Asa Hutchinson are the only 2 candidates that the media acknowledges. We do have a constitutional candidate, which is Curtis Coleman, who's in the race. This race could easily come down to a runoff because things will be so tight. And they have a number of third-party candidates there that could also lead this thing into a runoff. The lieutenant governor's position, the secretary of state, the state auditor, state treasurer, and land commissioner. The real importance of these positions is that we have 7 constitutional officers, and for the last 100 and some odd years, the Democrats have controlled those. That's why our election commission has 2 Democrats on it and 1 Republican. If we can take 4 of those positions with Republicans, that will flip, and we'll have 2 election commissioners, and our election commission will be run by Republicans in this county instead of Democrats. So that's the majority of the reason that you'd like to see that. And if you look down at who's retiring in those positions, all of the strong Democrats are retiring. 1 or 2 of the Republicans are staying, and it looks very likely that we may have 6 of the 7 constitutional officers this year in the Republican position, so our election commissions will change. Going down from there to the federal races, U.S. Senate, you got Mark Pryor and Tom Cotton, very close race. Here again, you could end up in a runoff here between those 2, which would change things dramatically because you have some independent party candidates in that. It will be a race that could end up tight. Arkansas is strongly Republican at this time, so that Tom Cotton has a better chance than Mark Pryor in the current polls. On the U.S. congressional race, you've got Tim Griffin retiring over in Little Rock, and it's likely that a Republican will take that, but not as likely as it is in District 4. District 4, which we're in, and I believe we have a map up here of the white area. The yellow one was the one that Tim Griffin's retiring from. But anyway, in this district, a Republican is favored by 15 points. So whoever wins the Republican side is likely to beat James Lee Witt, who's the lead candidate on the Democrat side. The Garland County Tea Party has endorsed Bruce Westerman in that race. Tommy Mole is the other really strong candidate in there. Anyway, that's my comments about what we have coming up. You know, see these candidates in here and please offer to help them in their races, help them financially, jump in and volunteer to work with them, please. Thank you.
Just a couple of final housekeeping deals to let you know about. One is our next meeting is March 13th, at which time we're going to talk all about candidates in a lot more detail. If you've not been here before, and if you'd like to be on our mailing list and be a member or whatever else, be involved in our activities, we have some cards underneath your chairs that if you fill those out and leave them, and on the back of those cards, if you would like to be actively involved in helping us in this campaign coming up, circle some of the things that are of interest to you. We have we've gathered a lot of those from our last meeting in November, and we're going to be really organizing pretty quickly here to get a lot of folks involved in this upcoming campaign. We even had some tonight that were here helping us put this stuff together. We've got some videos for sale if you'd like to help raise some funds for us. 3 for $10 in the lobby out there, and I hope you might be willing to do that. And let's also let you mention to you that we have what I think is a pretty good growing website right now. It's called www.garlandt.com. Got a lot of good information on it. I encourage you to go there and learn more about us. And we do put out a weekly newsletter. And if you'd like to be on that newsletter list, see what we're up to, fill out one of those cards. With that said, it's been a long evening. I'd like to thank our two candidates, our two debaters for being here. Bob Triggers for putting together all of our videos and slides. And with that, we'll dismiss and hopefully see you next time. Thank you.